Okay. First of all, thanks, Raluca, and I also want to thank the previous speaker and the previous speakers, so also those from the first panel, and clearly a special thank goes to Sasha and Mor for inviting me. We have been asked to talk about standards and avenues. So as regards avenues, the point I will make is that the avenues that we have to protect the freedom of expression of legal professionals under EU law are, let's say, the ordinary judicial remedies available in the EU legal order. And first of all, the infringement procedure and the preliminary ruling mechanisms. Whereas as regards the standard issue, I think that the peculiarity in this field, at least at this time, is the fact that the protection does not derive from the provisions of the EU primary law specifically devoted to the freedom of expression. And I'm referring notably to Article 11 of the Charter of Fundamental Rights for reasons that I will explain in a while, but rather we can have a sort of indirect protection through the parameters which concerns judicial independence. And so I will be back to that Article 19 of the Treaty on European Union that Thomas mentioned before, and also to Article 47 of the Charter of Fundamental Rights. So first of all, a brief outline of my presentation. I will start with the standard issue. And I will make the point that there is, as far as the freedom of expression is concerned, a parallelism between the protection offered under the European Convention and the European Charter of Fundamental Rights. But we have a problem because the scope of application of the Charter is a limited one. And this limited scope of application is an obstacle to bringing pure cases concerning the freedom of expression of legal professionals before national courts and before the Court of Justice. But as I anticipated, we can argue that there is the possibility of an indirect protection of the freedom of expression of of at least judges through the parameters concerning judicial independence. And so we can elaborate on the case law that the European Court of Justice has been developing in the last years as a reaction to the rule of law crisis. And as a last point, I will try to see whether EU law can also contribute to protecting directly or indirectly the freedom of expressions of lawyers. So first of all, the standard concerning the protection of the freedom of expression under the EU Charter. As I said, the relevant provision is Article 11 of the Charter, notably the first paragraph, which is devoted to the freedom of expression and information, and which states that everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. So we know that since the entry into force of the Lisbon Treaty, so 1st December 2009, the Charter is part of the primary law of the Union. And there is an important instrument which is not part of EU primary law, but it's very relevant for the use of the Charter. And this instrument is called explanations related to the Charter of Fundamental Rights. And the explanation related to Article 11 states that this Article 11, paragraph 1 of the Charter corresponds to Article 10 of the European Convention on Human Rights. And this information is very relevant because when we have this kind of correspondence, this means that we need to apply a specific provision on the interpretation of the Charter, which we find in Article 52, paragraph 3 of the Charter on scope and interpretation. And this provision states that basically when we have this correspondence between the Charter and the European Convention on Human Rights, the standard of protection under the Convention represents a minimum standard of protection under the Charter. So there is the possibility to provide a higher protection, but the convention standard sets the minimum level of protection. And the explanation relating to this Article 52, paragraph 3 states that in order to determine the standard of protection under the convention, which then sets the minimum standard for the Charter, we need to take into account also the case law of the Strasbourg Court, and also the parallelism covers limitations. So basically, everything was said in the previous presentation about the Article 10 of the European Convention also applies to Article 11 of the Charter of Fundamental Rights. But as I said, we have a problem, and this problem is the reason why at present we don't have pure freedom of expression cases concerning legal professionals pending before or decided by the Court of Justice. And the problem is connected to the limited scope of application of the Charter. When we consider the European Convention, we have a general scope of application because, as stated by the first article of the European Convention, the high contracting parties must offer the protection granted by the Convention to everyone within their jurisdiction. But for the Charter, we have a different rule as far as the scope of the protection offered by the Charter is concerned, and notably as far as the relevance of the Charter at the national level is concerned, because as far as the activity of the EU institutions is concerned, there's no doubt that the scope of the Charter is general, and any acts adopted by the institutions, agencies, organs, bodies of the Union must comply with the Charter. But we have a different rule with respect to the application of the Charter at the national level. So as you can see, Article 51 of the Charter, which is actually devoted to the field of application of the Charter, states that the provisions of the Charter are addressed to the member states only when they are implementing Union law. And basically this means that in order to invoke the Charter in a specific case, there must be a rule of EU law other than the fundamental right of the Charter at issue, which is applicable to the case. So it is not sufficient to say, in this case, there seems to be a violation of a certain provision of the Charter. This will not be enough to trigger the application of the Charter. But first of all, one must verify, and the judge or the lawyer must verify whether the case at issue falls within the scope of application of another provision of the primary law of the Union, so a treaty provision, or under the scope of EU secondary law instrument. For instance, the case is about the application of a regulation, is about the national measures implementing a directive, so on and so forth. It is not enough to say there seems to be a violation of a certain provision of the Charter. And this limited scope, I think, is the main reason why we don't have at present pure freedom of expression of legal professionals cases before the Court of Justice. But we can have an indirect protection thanks to the parameters that concerns the judicial independence, so at least in the case of the freedom of expression of judges. And here comes this Article 19 of the Treaty on the European Union that was mentioned beforehand by Thomas, which is a very important provision which basically describes the EU judicial system and, let's say, conceives this system as an integrated one, because there is one proper EU judiciary, which is represented by the Court of Justice of the European Union, but then there is also the national branch, which is represented by the courts of the member states. And as you can see, in this second part of the first paragraph of Article 19 TU, it is stated that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. So the organization of judicial systems is a matter within the remit of the member state. It's not something within the remit of EU law. But because of this Article 19, there is an obligation of the member states to ensure that their judicial system is able to ensure effective legal protection in the fields covered by union law. So this Article 19 can provide the link to the scope of EU law. So that link which is necessary in order to apply the provisions of the Charter. And which provisions of the Charter? Well, first of all, Article 47 of the EU Charter, which is dedicated to the right to an effective remedy and to a fair trial. And notably, the second paragraph refers to the guarantee of an independent and impartial tribunal. So everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal previously established by law. And here I put a part of a quite recent case of the Court of Justice, and quite groundbreaking case of the Court of Justice, the Repubblica case, which was decided in 2021, which, let's say, summarizes very well this link between the Article 91, paragraph 1 of the Charter and the Article 47 of the Charter, and also suggests us that measures which concerns which attacks, let's say, the freedom of expression of judges may become relevant under EU law. So you see, first of all, the court states that the organization of justice in the member states is within the competence of the member states, but they have to respect their obligations deriving from EU law. And first of all, their obligations deriving from Article 19, paragraph 1, second subparagraph. And in providing this effective judicial review in the fields covered by EU law, the member states must ensure, first of all, the independence of the judges, which is essential for judges to be able to cooperate with the Court of Justice under the preliminary ruling mechanism, and which forms part of the essence of the right to effective judicial protection and the fundamental right to a fair trial provided by Article 47 of the Charter. And then there is this part which is very relevant for us today, because the court stated that in accordance with the principle of the separation of powers, which characterizes the operation of the rule of law, the independence of the judiciary must in particular be ensured in relation to the legislature and the executive. Judges should be protected from external intervention or pressure liable to jeopardize their independence. They must be protected by any forms of direct influence, but also from types of influence which are more indirect and which are liable to have an effect on the decisions of the judge's consent. And this could be, for instance, disciplinary measures, which basically are the consequence of opinions lawfully held by judges. So at present, as you know, we have many cases concerning so the independence of the judiciary in some of the member states. We don't have cases in which there are arguments relying directly to the freedom of expression, even though some of these cases can provide an indirect protection, because in some cases there was also a problem of attacking the freedom of expression of judges. But in the future, we may see also explicit arguments concerning the freedom of expression, and the entrance door would not be directly Article 11 of the Charter, plausibly, but still this connection between Article 19 and Article 47. Which judicial avenues are available? As I said, the traditional ones, so the infringement procedure and the reference for preliminary ruling, which are not equivalent. There are some important differences, and an important difference is the different requirements to trigger the competence of the Court of Justice. So as the Court of Justice pointed out in this other Polish case, the Miastolowicz case, in an action for failure to fulfill obligations, so in the infringement procedure, the court must ascertain whether the national measure or practice challenged by the Commission or a member state contravenes EU law in general. So there is not the need to have a connection with a concrete dispute before national courts. Whereas, in order to trigger the competence of the Court of Justice in the context of proceedings for a preliminary ruling, there must be a connecting factor between the dispute and the provisions of EU law whose interpretation is sought. So the case must concretely concern a restriction to the judicial independence of a judge or of a court. The task of the Court of Justice is also different in the two procedures, because in the infringement procedure, we have a direct control on the compatibility of national law with EU law, whereas we have an indirect control in the case of a preliminary ruling mechanism. And also the consequences are very different, because in the context of an infringement procedure, if the Court of Justice finds that there is a violation, there will be the duty of the member state to put its legal order in compliance with the EU law, and there will be the possibility of a second infringement procedure with financial sanctions, so pecuniary penalties, if the first judgment is not respected. So for all these reasons, I think I agree with Advocate General Bobek that we should call for much more infringement procedures in such situations, as this seems to be the most important, the most effective instrument. And it is important to say that even though, as we know, it is only for states or the Commission to start the infringement procedure, there is the possibility for individuals to put the attention of the Commission or of the member states, but they are quite reluctant in starting this kind of infringement procedures. But there is the possibility for an individual to raise the attention of the European Commission on this situation. Clearly, preliminary rulings are fundamental. The problem then may be that it is for the judge to uphold the solution of the Court of Justice, and we know that these judges work in a very complex environment. I will try to go swiftly to the conclusion, even though I have two further points, and one point concerns exactly the importance of the preliminary ruling mechanism. I think that we can consider the possibility, the faculty, and sometimes the duty of national courts to use the preliminary ruling mechanism as a sort of EU-specific component of the freedom of expression of judges. So the preliminary ruling mechanism is a mechanism of dialogue between national courts and the Court of Justice. And in this respect, we have vast case law of the Court of Justice, which states that national courts has and must have the widest discretion in referring matters to the Court of Justice. So very recently, in this infringement procedure against Poland, this was delivered in July 2021, the Court of Justice stated that it is in contrast with Article 267 TFEU, which is the provision on the preliminary ruling mechanism. It is in contrast national law, which exposes national judges to disciplinary proceedings as a result of the fact that they have made a reference for a preliminary ruling to the Court of Justice. These judges must not be exposed to disciplinary proceedings or measures for exercising a discretion which is essential to judicial independence. And finally, last point. So we have quite a lot about indirect, we can say, protection of the freedom of expression of judges. But what about lawyers? And again, we don't have cases, at least to my knowledge so far, but we can state that we have a very consolidated case law on the free movement, according to which any restrictions to the exercise of free movement must comply with EU fundamental rights. And this case law can be relevant in the case of lawyers that are offering their services in another member state, so in a member state other than that of nationality. But there is also a case currently pending before the Court of Justice. This case, I cannot pronounce the name, which may open, but we don't know, we need to wait for the judgment of the Court of Justice, which may open a scenario of protection also for lawyers that are exercising their activity in the member state of nationality, because here the one of the many interesting questions raised, and notably raised by the disciplinary chamber of a national bar, and so the one of the question is whether a measure which, a disciplinary measure which may end in the radiation from the order of a lawyer can be considered to be as an measure affecting an authorization, and therefore fall within the scope of the Services Directive, and notably of this Article 10, paragraph 6, which states that there must be the possibility to challenge any decisions basically concerning authorizations. And there is an interesting opinion by Advocate General Bobek, which states that this provision can apply also in the case of lawyers performing their profession in the member state at issue. The main case concerned the lawyers of Donald Tusk. And Advocate General Bobek is also arguing that these kind of disciplinary measures, which may end up in the radiation from the order, must be considered as authorization under the meaning of Article 10, paragraph 6, and therefore there can be a right from EU law to have a challenge before an independent courts. And in the case at issue, the disciplinary measure was the consequence actually of opinions, of comments made by these lawyers on a prospect criminal charge for Donald Tusk. So it will be very interesting to see what the court will decide on this case. Sorry for abusing of my time, but this is the end.